And firstly, congratulations on your recent win in the H-1B visa case. And if you can please share some of the messages that you got on social media. We were tracking your account. I mean, we were looking into the accounts and people were really congratulating you and on your big win. So if you can also please show it on the screen for the viewers, we would like to.
Yeah. So a lot of the cases that we're working on right now have a common element, which is the government didn't give the interested party in the case notice and an opportunity to respond prior to issuing what amounts to be a punishment, or what the law calls a sanction. So in the Narambalada case out in Seattle, in the Western District of Washington, it was one of those issues where the employees had all been selected in the H-1B cap lottery, been assigned a cap number, were working, and then the government yanked the rug out from underneath them and said, your employer did something wrong, we're taking away your cap number. And so it's important to recognize that when you get your initial H-1B approved, there's two different benefits going on. One is the benefit to the employer, which allows them to hire you and make money off of you. And then the other benefit goes to you, the employee, which is your right to change jobs, your right to extend indefinitely if you have an approved I-140. And so what they do in these cases is they take away the employer's right to employ and also try and strip the innocent employee of their cap number. And so very quickly in that case, in Narambalada, like early on, the government conceded the employees did nothing wrong. They're not the ones that are, alleged to have committed fraud. It's all the employer. And then they said, even if that's the case, the court shouldn't hear this issue and they should dismiss the case. And our argument has always been that the interested party in the cap number revocation is the employee, and they're the only people that get noticed because it's all on them. It's all the negative impact is all on the employee. And so that was our argument pushing, and there's a couple of other arguments, but that was our lead argument. And so the court says they are good to go forward and press their case in federal court.
Okay, great. Well, before we move into and before we dive into the details of this case more, I would like to actually show our viewers those congratulations messages by people on your big win. If you can please share those screenshots or those images here, please. Okay, and yeah, as people can see on their screen, see these messages from people, and can we also have more? You are fighting the good fight. And then if we can also thank you, Jonathan, for your support. And this is about the Sridhar's case, actually. And if we can also show more, see, too many messages actually for John. Congrats on the great work, make them pay. And this is awesome, John. Thank you for sharing. What a win. This is incredible. So a whole lot of messages from the people, actually. So, and now, John, coming back to you again, and now I would like to talk more about the case. If you can please, also walk us through how you and your team actually stumbled upon this case in the first place, and what actually made you notice it.
So in the Narambalada case, it was all about the multiple registration issues that were, endemic in the 2022 and 2023 fiscal year lotteries. And I guess the 2024 as well was a hot mess. So what we saw is people getting selected in the lottery, working for the employer. A lot of times they didn't know that they had been entered in by multiple companies. They thought there was just one offer of employment. And the reason for that is manyfold. Sometimes the employers would get the list of employees that they wanted to hire. They would share with some other company, and then they would apply without the employee knowing. They also were using recruiting companies back in India who was selling the same list of employees to multiple different employers. And that really ratcheted up the number of duplicate registrations that were going on. But what we noticed is that you know, when they were revoking all of these H-1s, most of the time, the employee had already moved on. They'd already transferred their H-1B to a new employer. And so the old employer typically does not respond to the notices of intent to revoke because USCIS has said they're going to criminally prosecute people. And so nobody wants to say anything. And those go unanswered. And the only person that really is impacted is the employee because they're the one whose cap number is getting stripped.
Yeah.
The initial employer has already lost their right to employ. And so, they get blindsided by this at their new employer with a new notice of intent to revoke the second visa. And so if you were selected in those years that were tainted by the multiple registration, you should probably be checking your case status page regularly on the visa just to make sure that USCIS hasn't revoked it without telling you. So you're not similarly blindsided. But the employees that came to us, they were obviously they had done nothing wrong. They were frustrated with the system. And so we looked into it. The first thing right off the bat we noticed is that under federal law, the statute, the immigration statute, you cannot strip a cap number away from an employee for fraud unless they're the one that commits fraud. And in these cases, the government was very clear early on. Their initial defense was there's no fraud on the employee's part because we're suing them, challenging fraud findings against the employees as well. So very quickly, they backtracked on that. And so under the statute, the employee didn't commit the fraud, so they really shouldn't have their cap number stripped away for the actions of a third party. The other issue I think that is more interesting from a nerdy lawyer perspective is that the anti-collusion rule that is being used to justify all of these revocations was never published the way the rules are supposed to be published. So USCIS went through this long rulemaking process where they provide notice to the public, they take comments, they analyze comments, and then they publish a final rule. They did that when they recreated the new lottery back in 2019. And they changed the structure of the lottery. So they went through the rulemaking process, and a lot of people commented, very well-known people within immigration commented that if they didn't change the structure, it would lead to massive duplicate registrations and frivolous filings that would cause unused petitions. And so people just wouldn't have enough work for the number of employees that they got selected for. USCIS's response to that was, we're not worried about it. What we'll do to solve that problem is we will just require them to make an attestation that they will file a petition. Now, notice there was no attestation about unfairly, working with another employer, nothing like that. So the first 2 years the lottery goes off without really much of a hitch. It's not that crazy. And then the numbers started to get crazy. USCIS realized they had screwed up. But instead of going back through the process that they're required to under the law to fix it and create new rules and put the public on notice, they essentially just put it up on their website, and that was the extent of their notice. So we're challenging that because they really did not follow the process. The federal courts are pretty clear. When you create a rule like that, you have to give the public notice in a very particular way, which is publishing it in the Federal Register. That's the only way that people know officially what's happening and what the agency is going to be doing. And they didn't do that. And so I think they have a rulemaking procedural problem. Almost all of the cases I do come under the Administrative Procedure Act, and that's the handbook the government has to follow when they make any type of decision or rule. If in my line of work, if we're arguing about facts it's going to be a rough case. But
Mm-hmm.
when we're arguing about procedure, that's when we're at our best. And pointing out the procedural flaw in the rulemaking, I think, is ultimately going to be what wins the case.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.